Great. Mr. Rao, you can come right up to the podium there. Oh. We'll go on the record in People versus David Rauch, file number 255045. Today is the date and time set for sentencing in this matter. Mr. Rauch is present here in the courtroom today. Mr. Rauch, did you have a chance to go through the pre-sentence report and talk to Mr. Seeger about that? Yes. Okay. Mr. Seeger, are there any additions, deletions, or corrections?
There were some attempts at making some additions, corrections, or deletions, mostly related to his prior criminal history. However, when I talked to the Department of Corrections, Ms. Wagner, she indicated that she had gone through lean or fine, and she was unable to verify some of the things that Mr. Rao had indicated in terms of sentencing. But because she's gone through it, Your Honor, there's nothing we can do to change this.
Okay. Are there any challenges to the scoring of the guidelines?
There are not, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
Your Honor, there's very little to add to the report. This was a case where the defendant was already on probation for a drug offense to this court. And not only did he commit a new drug offense here, but also allegedly in Grand Traverse County, although it's my understanding that might be dismissed. Although the defendant did complete some treatment on probation, he clearly did not completely address the defendant's substance abuse issues. And in my view, it's not economical to continue to spend taxpayer dollars on supervising and treating him on probation when he's demonstrated he cannot or will not comply with that supervision. Therefore, I would support the recommendation of a jail sentence in this case. The defendant already has 128 days credit, but I think the circumstances of this case where he's committing drug offenses while on bond for a drug case call for something more than just 128 days, something beyond the guidelines, Your Honor. I would ask the court to sentence the defendant to 8 months.
Your Honor, in terms of sentence, I would just ask the court to follow the recommendation and give him a county time sanction. Mr. Rao has expressed a want to get into treatment. He does have a plan going forward in terms of effectuating that. He's hopeful that to the extent that the court sentences him to some kind of additional jail time, that it would allow him to get into treatment at its earliest possible point. In speaking with Mr. Rao over the course of time, I've known him for a period of time. He's had a substance abuse problem for a period of time. And he's always tried to keep it under control. But I think to a certain extent, much like many other people who have substance abuse problems, he's had a relapse, and it's unfortunate for him. But to that end, Your Honor, he's tried to make things right. He wants to get his daughter back in his life. He wants to do right by her. He wants to do right by himself. And moreover, he wants to live a substance abuse-free lifestyle, which I think during this time of incarceration, it has been an opportunity for him to review his life, where he wants to go with it, and ultimately trying to find the mechanisms that will allow him to remain substance abuse-free. So to that end, Your Honor, I would just ask the court to give him a county time sanction with the understanding that he can theoretically get into some kind of drug treatment situation once he's released.
Thank you. Anything you wanted to say today, sir?
I just want to say that I've been in jail for quite a while now, and it's made a big impression on me. I've had a lot of troubles in the past, and I'm trying to get through everything, and I'm trying to get my daughter back in my life, which I haven't seen in 5 years. I miss to death, you know, and I'd do anything to have her in my life, including being clean completely for the rest of my life, you know. And when I had her in the past, I never did do drugs, went in front of her, around her, or nothing. I kept myself clean. And it was her being taken from me that really affected me in life and got me to where I pretty much just gave up on hope and stuff. And now I have a chance to get her back in my life, and I really want to go forward and try to do that.
I did read through the report, so I'm familiar with the charges that bring you here to court today. I'm also familiar with your personal background and circumstances based on the information in that report. I take all of that into consideration along with what you've had to say here today and what the lawyers both had to say as well. It's apparent to me that you do have a substance abuse problem that needs to be dealt with. If the attempts through probation weren't successful, that doesn't mean that you can't seek it out on your own and get help for yourself. And sometimes that's what it takes, is for you to decide that that's what you want to do because you want to do things like have your daughter in your life, and not because a court's ordering you to do it or a probation agent is telling you you have to do it. And so I hope that's the choice that you make going forward. In terms of a penalty here, it is an aggravating circumstance that you were on bond. It's my experience, especially in drug cases, just because a bond tells you you shouldn't use drugs doesn't mean that your addiction isn't still there and that you don't have a problem not using. And so while it's an aggravating circumstance, when it's a substance offense, I also recognize that that piece of paper doesn't cure your addiction and that there's still that need and drive to use even when you're on bond. That along with just the general circumstances of your case, I think a penalty within the middle of the guidelines is appropriate. The guidelines are 0 to 11, which means the court could not impose any jail time at all. But I do think that, or I could go up to 11 months. I think that a sentence within the middle of that guidelines addresses the punishment for your behavior while on bond, and your wrongful behavior in using and possessing in the first place. So the court is going to sentence you to 180 days in the Calcasieu County Jail. You do have credit for 128 days served. Court is going to order a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. You do have the ability to seek an appeal of this sentence, and we're going to provide you with some papers that explain to you what your appellate rate is. Mr. Seeger, if you can have Mr. Rauch acknowledge receipt of those.
For the record, Mr. Rao is executing a copy of this appellate rights. Returning a copy of the court.
Thank you. And Mr. Rauch, you are remanded to the custody of the county at this time. Good luck to you going forward. Versus Clayton Ross, file number 255057. Ross present.
He is,
He's lodged.
Oh,
he's lodged. He'll be.
Sorry, Your Honor, I messed up my docket. I had it attached to Judge Hunter's docket, so.
That's what I figured.
Tomorrow, so.
That's okay.
That hearing had a little bit of everything. People v. David Ralph was a classic example of a sentencing hearing where the law, the person, and the possibility of change all showed up in equal measure. Judge George Mertz once again maintained his measured, thoughtful courtroom presence, and what followed was a fair but firm handling of a case involving relapse, missed opportunities, and one man's sincere desire to turn things around. Mr. Ralph appeared for sentencing after being convicted of a drug-related offense while already on probation for another drug charge in the same court. That's the kind of fact pattern that gives judges and prosecutors real pause. Prosecutor Mr. Siegler didn't dance around the point. Ralph had already been given the chance to succeed on probation, had completed some treatment, but ultimately committed new offenses, one in the court's jurisdiction and allegedly another in a neighboring county. In Mr. Siegler's view, it didn't make sense to continue investing in probation supervision when Ralph hadn't made good on that opportunity. His recommendation? 8 months in jail more than the 128 days Ralph had already served. Defense. Attorney Mr. Seeger pushed back gently. He acknowledged Ralph's relapse but emphasized the human side of the story. Ralph, now facing a turning point, was determined to change. He expressed a desire to reconnect with his daughter, who's been absent from his life for 5 years. That goal, Seeger argued, is motivating Ralph more than any court order could. There was no request for leniency without consequence, just a hope for a sentence that balanced punishment with a pathway to treatment and stability. And then we heard directly from Mr. Ralph. His words were plain-spoken, heartfelt, and notably devoid of excuses. He openly admitted he had given up after losing contact with his daughter, and that the pain of that loss drove him into addiction. Now, with the possibility of reuniting with her, he sees a way forward, and that seemed to resonate. Judge Mertz took all of that in and gave a thoughtful explanation for his decision. He acknowledged the aggravating factors committing a new drug offense while on bond, but also understood the reality of addiction. A bond condition telling someone not to use doesn't cure dependency. The judge emphasized that meaningful recovery comes not from court orders but from personal choice. Still, accountability mattered. He opted for a sentence in the middle of the 0 to 11-month guideline range, 180 days in jail, with credit for the 128 days Ralph had already served. The judge also imposed the standard fines, fees, and costs, and made sure Ralph understood his right to appeal. The tone throughout was calm, composed, and respectful. There was no drama, no finger-pointing, just a judge, 2 attorneys, and a defendant, all navigating the weight of a tough situation. Mr. Ralph's future remains uncertain, but he left that courtroom with a sentence that reflects both the seriousness of his actions and the hope that this chapter might be the last one written in that pattern. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.